Good afternoon, everyone. And in and around Diwali, to talk of pension seems to be it gives pleasure also, because as we all know that pension is known to be considered as a deferred payment, and it is also considered that it is not a bounty. Not one, but there are series of judgments having a common thread running between them, to the effect that it is on account of the service which one has rendered. But a common word, pension, simplicity looks that it's one. But as you further and further specialize, you find there are, they say as wheels within wheels, that there are different types of pensions. That is service pension, family pension, special family pension, liberalized pension, disability pension, and war injury pension, invalid pension, reservist pension. Since there are larger number of issues within pension itself, we with Navdeep Singh, since it's more like a formative form where we ask questions, which we believe that it should cover all the larger aspects as such in the pension, though more emphasis would be on the military pension. And we all know that Navdeep Singh is the founder president of the Armed Forces Tribunal, where it's primarily dedicated towards the redressals of the grievances of the armed forces. And he has also written various books which are regarding the armed forces itself. His first book was Fauj Hai Mauje, then Soldiers Know Your Rights, then Pension in the Defense Services, Maimed by the System, and the latest book, which actually encouraged us to request to Navdeep Singh, that is Military Pensions, Commentaries, Case Laws and Provisions, which are all now available also on the online. And it's doing well in the market, and it was surprising, though it was during the lockdown time and pandemic, but people latched up to know the insights. And during this webinar, we will not be taking any personal questions. If anybody wants an advice, they can ask the counsel as such. Mr. Navdeep Singh will be broadly covering Major Navdeep Singh, an advocate, would be broadly covering the contours of the various aspects of the pension as such. So, as a common man or a person who intends to understand, Mr. Navdeep, people actually want to know what are the constitutions of the courts on pension as such, because sometimes one feels that it can be before the civil court, AFT, or any other tribunal, or the High Court or the Supreme Court directly. So just give the broader aspects. What are the major constitutional courts as such? Where we can.
Mr. Chatrat, you've explained in brief the concept of pensions, and you also rightly called it a deferred wage. That essentially sums up what pension is all about. So on your specific query upon which courts to approach for grievances related to pensions, and also what courts have to say about pensions and pensionary benefits, it all depends upon the jurisdiction. For example, if you're a central government civil employee, you would approach the Central Administrative Tribunal, the CAT. If you're a former military employee, you'll be approaching the Armed Forces Tribunal. If you're in the state government, certain states have their own administrative tribunals, while certain states don't. So in that case, you go to the High Court directly. And as per the judgment of Jitendra Kumar, which was a constitution bench judgment of the Supreme Court, one cannot approach the High Court directly for pensions. So for example, if you're a civil central government employee, you have to approach the tribunal that is instituted for the purposes of service matters. You cannot go to the High Court directly. It's only thereafter that you can approach a division bench of the High Court and then the Supreme Court. And even the Supreme Court cannot be approached directly. Though we have cases in the past wherein people have approached the Supreme Court directly, but after Jitendra Kumar, which was, as I said, a constitution bench decision, the court of first instance would be a tribunal, not the High Court or the Supreme Court. But of course, in states, we approach the High Courts directly where there is no state administrative tribunal. Now, what have the courts held about, or what have the courts commented upon the concept of pensions? We all must be knowing, and I mean, especially the people with a legal background, that it was way back in 1971 that the Honorable Supreme Court in a Constitution Bench decision in Dyoki Nanda Prasad said that pension is a right of an employee. Pension is a right of a pensioner, of a former employee. It is not a bounty. It is not something which is to be paid at the discretion or the sweet will of an employer or the state or any instrumentality of the state or the government. So that actually set the basis and the flavor for what was to come on pensions. And interestingly, the words of the Constitution Bench were not words of the Supreme Court per se. And people would be surprised to know that the concept and the words picked up by the Supreme Court were from a judgment of our High Court, of the Punjab and Haryana High Court. So the Punjab and Haryana High Court was cited with approval by the Supreme Court, and that's how the Supreme Court ultimately came to that conclusion. And thereafter, most would be aware of DS Nakara's decision, DS Nakara versus Union of India, which is again a landmark decision in pensions, and which was on cutoff dates in pensionary policies. And in that too, the same principles were reiterated, that it's a right of an employee, and it does not depend upon the sweet will, and policies cannot be arbitrary, and also that financial implications cannot always be cited in matters of pension. Then this was in 1982. Then another important decision later, or I would cover the very recent decisions. A very interesting decision was in the year 2013, which was state of Jharkhand versus Jitendra Kumar, wherein the Supreme Court held that pension is akin to property under Article 300A. And so it equated an employee's or a former employee's pension with property. And the Supreme Court ruled that pension is property as far as the constitutional principles are concerned. And then very recently, in yet another decision, that is State Bank of India, which you would be aware of, Mr. Chatrat, versus Radhesham Pandey in 2020, a three-judge bench held that wherever there is any doubt on any interpretation in pensionary policies, the benefit has to go to the employee concerned or the pensioner concerned. And this essentially sums up the spirit, because in a welfare state, the courts, the constitutional courts, the Supreme Court and the High Courts have a number of times held that wherever there is a beneficent or a beneficial scheme or a welfare scheme or a pensionary policy involved, in case there is a doubt, then the benefit of doubt goes to the employee or the pensioner and not to the state. And hence, the underlining factor has been that kindly be liberal in interpreting pensionary policies. It's like social justice. So pensionary policies, as per courts, have been directed to be interpreted very liberally and not literally. That sums up the spirit of how constitutional courts and how judicial fora have dealt with the concept of pensions. Mr. Chatra.
Yeah, Mr. Navdeep, since you were talking of the AFT, large number of people still feel as to whether the leave would have to be taken and then you have to approach the Supreme Court. What is the now exact position as to whether you can approach the High Court? Because after the L. Chandra judgment, the lawyers do know that it was in respect of central government employees, where therein after it was said that under the power of superintendence, you can always approach the High Court. But in the AFT matter, there was a provision that they said you go to the Supreme Court directly itself. Then that Roger Matthews judgment came, and now what is the basis for that? Ultimately, do you approach the High Court or do you straight away go to the Supreme Court against the order passed by the Armed Forces Tribunal?
As we all know that a statute cannot amend the constitution or cannot alter constitutional policies. So the power of writs, that the writ jurisdiction under Article 226 of the Constitution cannot be taken away by even a constitutional amendment, because it forms a part of the basic structure, or by a statute. So earlier we were going to the High Courts, but in 2015 there was a judgment by the Supreme Court in Major General Shrikant Sharma's case, which said that although High Courts have the power, but since an appeal has been provided to the Supreme Court, it would be desirable that people move the Supreme Court. But now the problem was that the appeal to the Supreme Court, as per the AFT Act, only lies in points of law of general public importance. So if it's a matter personal to the litigant, for example, pension or promotion, etc., etc., as per the Act, strictly there is no appeal even to the Supreme Court unless you can aver a point of law of general public importance. Then came the recent Constitution Bench judgment, which disapproved the view taken in Shrikant Sharma and said that there is no bar on the High Courts in entertaining petitions from the Armed Forces Tribunal, just like the Central Administrative Tribunal. And they've again endorsed Jitendra Kumar again. For example, Jitendra Kumar, as you know, is a 7-judge bench, Constitution Bench judgment, which says that the powers of the High Court cannot be ousted, and it is desirable that a person approaches a division bench of the High Court and then the Supreme Court.
Yeah. Now we have understood the constitution of the courts. So all matters under the AFT, let's assume anybody is aggrieved. And now another questions, which before I take the next question, it comes out. A lot of people feel that under the Armed Force Tribunal, whether it will be only Army, Navy and Air Force or BSF, CRPF, they would also fall within that.
No, only Army, Navy and Air Force, and only those people who are serving or who are retired and who have served under the Army Act, Navy Act or Air Force Act. Not even, for example, if you have an applicant who wants to join the army, even he or she cannot approach the Armed Forces Tribunal. And BSF, CRPF, ITBP, etc., all Central Armed Police Forces, they can approach the Honorable High Court directly. They go to a single bench, for example, in our High Court, and then in case they're aggrieved, they can go to the division bench under the latest patent jurisdiction. But the Armed Forces Tribunal does not cover the Central Armed Police Forces.
Though they are the central government employees, since few questions, though I might be knowing, so meaning thereby, even though they are the central government employees, they will not go to the Central Administrative Tribunal.
No, they will not, because the Administrative Tribunals Act excludes the armed forces from operation, and the Central Armed Police Forces are also armed forces of the Union, but they are not defense services. And the Armed Forces Tribunal Act covers only the people who are under the Army Act, Air Force Act and the Navy Act, or their heirs and dependents, etc., as insofar it relates to the service matters.
So under the Central Administrative, they have to be specifically notified whether they would be.
They have to be specially notified, and they cannot be from the armed forces. So CAPFs are out of the CAT, and they are also out of the AFT. So they go to the single bench of the High Court directly. In case of our state, and in certain High Courts to a division bench also. It depends upon the local rules and orders of every High Court, but they have to approach the High Court directly.
Yeah. So another question, since we are discussing about pension, sometimes we see that the pay normally the pay scales or any other benefits are normally referred to a pay commission report, who looks into those reports, and then recommendations are made. And we also know that all the recommendations are not accepted as such, but whatever are accepted. And sometimes it so happens that the pay scales are recommended, but there is some anomaly, and then the normal course is on the representations of the pensioner association or in-service people. They represent, and then there is a constitution of an anomaly committee. And then sometimes it so happens that as and when the anomaly committee refers, and then they impose that particular cutoff date, maybe after a month or so, that we have accepted that there is an anomaly, and then they impose that particular date. Now, some people feel two issues normally come before the honorable court is, or tribunals, I can say. Court, when I say courts, it will also connote, for the clarification of the participants, that it will also, in a wider connotation, would include the tribunals like the AFT and the CAT. Then another impression in these cases are as to whether these cutoff date, what has been recommended and implemented by the anomaly committee, should be implemented from that particular date. And then another situation is carved out. Let's assume there is a gratuity. Gratuity normally, not normally, it is a one-time time of payment, as to whether there could have been a difference of that cutoff date, and how the court has evolved with the flux of time as to what is the law in general for the imposition of the cutoff date, where one feels it can be challenged, or to the effect that it should be implemented when the main recommendations have been recommended, considered, and accepted.
That's a very, very important and a very pertinent question. The law on cutoff dates is a complex issue, but still it is very simple. See, the thumb rule is that whenever there is a betterment or a liberalization or an improvement in a current pensionary policy, it has to apply to all retirees, irrespective of the cutoff date, but with financial benefits from that particular cutoff date. So, for example, you introduce a new system of calculation of pensions for existing retirees and pensioners from 2016, January 2016. So that, or January 2006 or January 1996. So that new liberalization or improvement in the system of calculation would apply to all past retirees, but with financial effect from that cutoff date. So this is the basic thumb rule. Now, and of course, DS Nakara was also about the same, that you cannot, discriminate between two sets of retirees. A homogeneous set cannot be discriminated in that manner. So DS Nakara Constitution Bench was also on the same issue. There are multiple judgments. KJS Buttar on the military side is there. AN Sachdeva versus MDU, which Mr. Chhatras, you are also aware of. Then a latest judgment was All Manipur Pensioners Association versus State of Manipur. Then another very important judgment was Kalakurichi Retired Officers Association versus State of Tamil Nadu, laying down the same principle. However, there are a few exceptions. And as you rightly pointed out, you gave a very good example of gratuity. Now, these are one-time payments. So, for example, the amount of gratuity, maximum permissible gratuity, increases from 10 lakhs to 20 lakhs in the next pay commission. It is not that the past retirees can claim, that give me 20 lakhs because new people are getting 20 lakhs. So that's a one-time payment. So it's not a recurring cause of action. It is not liberalization of an existing pensionary formula. It is a one-time payment. Or say commutation. Somebody says that earlier such and such percentage was being commuted by such and such formula. Now the formula has changed. So give me a better commuted value based upon the new formula. That will not work. That does not come into the law of cutoff dates. Then another good example would be which people are under a misconception, that, for example, the system of pension itself changes. For example, you were on a contributory pension fund or a contributory pension scheme, and suddenly the organization introduces a regular pension scheme or a defined pension scheme. So you cannot say that I retired earlier and now a new pension scheme has started, so make me a part of the new pension scheme. That would be discretionary on part of the state or the organization concerned. That cannot be demanded as a matter of right. And that's what the Supreme Court says. And in such matters, there are two very important judgments. One is Union of India versus Justice S.S. Dewan, and the other is Subrato Sen versus Union of India. Both these judgments explain as to when the cutoff date would come into play, and there can be a cutoff date in one-time payments, for example.
And there's a Justice Khere's judgment also, where it actually defines, and which has been followed in this qualifying service by Justice A.G. Masina, High Court, to the effect that the qualifying service was reduced from 33 years to 25 years, and the cutoff date was imposed on 15/12/2011. Then factors were taken into consideration to the effect that as to whether what is the financial effect and import, and even if there is a financial effect and import, the court says that it has actually to be reduced in writing in the recommendations, etc., to the effect that what will be the implication if you implement that. If you do not note it down, then you cannot take that particular stand in the written statement or in defense of that order that this cutoff date is valid.
In fact, courts go a step further. The courts say that whether the differentia is the 1 rupee or whether it is any other amount, in case when there is arbitrariness or an affront to Article 14, then financial implications do not matter at all. So same in DS Nakara. For example, if there is an existing body of pensioners and suddenly there's a cutoff date, discriminating the pensionary formula, it will not be lightly upheld by the courts. You're muted, Mr. Chatrat.
No, in fact, I was just checking that watch party on the Facebook was not on. So I was seeing what was the reason. Because a lot of participants watch on the Facebook itself, since we are live on the Facebook.
Yes.
Now, another question arises is that the law has evolved with the flux of time, is that let's assume there is a judgment. And there are judgments to that effect. Our High Court has also passed a celebrated judgment of Reservist Singh and others versus State of Haryana, which says that similarly situated persons should be given the similar benefits. They should not be made to knock the doors of justice. Few judgments say that court should only help those who are vigilant about their rights. then courts have evolved with the flux of time that the area should be restricted to 38 months. So I understand the law keeps on evolving, and it is all what type of assistance also goes down to the bench, as Justice Rana has said that judges normally decide the judgments in accordance with what type of assistance is also provided. So normally, how do you divide this pension aspects of arrears, whether full arrears has to be given or 38 months arrears have to be given, or no arrears and simply set a revised pay fixation, or the court can also oust a person on account of the delay and latches itself, or in certain tribunals there are cases where it says it's simply set a barred by limitation.
Yes, Mr. Chatrat, again, a very important question which arises in courts every day. See, the law on arrears is not cannot be put in a straitjacket formula. Usually, not usually, the actual law says that since pension is a recurring cause of action and a continuing wrong, the concept of limitation or delay in latches does not apply to pension. It only applies to one-time causes of action such as promotion and dismissal, etc., where third-party rights can be affected due to flux of time. But in pension, the concept of delay and latches does not apply. However, what happens is that again, as a broad rule, if the right that you're claiming is flowing not from the rules directly, or not as a vested right, but from an interpretation by the court in your favor, then, and there is a long delay, then usually the arrears are restricted to 3 months prior to the filing of the petition. For example, in cases of disability pension in the army, where a disability is declared neither attributable to military service nor aggravated by military service, but the court comes to a conclusion that no, it is deemed to be attributable to service or deemed to be aggravated by service as per law laid down by the Supreme Court, and hence the person is to be granted benefits. And there is a long delay, 20 years, 30 years, 40 years, 10 years, then the court or the tribunal may say that, okay, areas are restricted to 3 years, which is a very valid thing to do. You are not expected to sleep away your rights for such a long time. However, these are cases where the benefit is flowing not from a direct right, but from a legal interpretation. Now, there's another example. The other example is that there was a vested right. You were entitled to something under the rules and it was illegally held back, or a constitutional court, that is the High Court or the Supreme Court, had struck down a rule or held something, but it was not implemented. And once it was not implemented, you come to a court after a few years saying that, see, there's already a judgment and I'm not being granted benefit. Now, in such cases where there's a vested right or where already there's a judgment which has not been implemented, the courts can grant full benefits, and they've been granting full benefits. The example of the first part, that is where your benefit is not as a matter of right, but as a matter of by way of a judicial interpretation, would be Union of India versus Tarseem Singh, a disability pension case wherein the medical board had not granted relief, but the High Court had come to a conclusion that no, please grant him relief. So in that case, areas can be restricted. The second example is, for example, Supreme Court's judgment in Mastan B case. Then the Supreme Court said that there is no question of restricting any areas wherein the person was entitled by, or S.N. Bharnale's case, was entitled by way of existing rules as a vested right, but still it was illegally held back. So there is no question of restricting areas. And in these cases, the restriction of areas by the tribunal or by the High Court was overturned by the Supreme Court. And Supreme Court said that no, when a precious right is being taken away from a person, then full areas need to be granted. So again, there's no straitjacket formula, and it would depend upon facts and circumstances of each case. But these are the broad categories wherein the right is flowing from a judicial interpretation and not as a vested one. Then areas can be restricted.
But according to me, I would still feel that, let's assume somebody feels that there is a grievance which is thought to be ventilated and redressed. One shouldn't wait for its generalization. Rather, it should be done, because we all know that there are judgments to the effect that client cannot be just like a kumkarna, that he can wake up at any point of time, or as we, in the legal term, we also use the terminology of vigilantibus, non-dormantibus. That is, the court helps those who are vigilant about their rights and not otherwise. But rightly put across that the areas, it all depends what type of relief you are claiming. Let's assume you have been dismissed. You just can't wake up one fine day and say that dismissal order is bad, and therefore it should be set aside. Since the consequential benefit would be my pay or a pension, Therefore, it should be given to me.
Absolutely, absolutely right.
Now, since we are discussing about pension, and I had just given not even a bird eye view or a snippet as such. In a common parlance, we do talk of pension, but if we actually examine into it, or we say as we deeper dive into it, then we actually find that there are a large number of different types of pension of different levels. I would just request you to just give as we say, not even a synopsis type, what type of various pensions are there in the military aspects, and what is the distinction between the different types of the pensions, like what is an invalid pension, what is a war pension, what is a special pension, what is a normal pension, what is a disability pension.
Yes, although the canvas is very huge, but still I'll try to briefly explain what the major types of pensions. See, the first is the service pension or the retiring pension. Now, this is available after 20 years of service, generally in most services. In the civil services, also it is the basic service pension is retiring pension is entitled after 20 years of service. However, for a person who's discharged by the government itself, it is just 10 years of service. After 10 years of service, you are entitled to pension if you reach the age of superannuation or you're discharged by the government. But if you're a premature retiree or a voluntary retiree, then it requires 20 years of service. On the military side also, for officers, it is 20 years of service. For Jawans and JCOs, junior commissioned officers, it is 15 years of service. So an officer becomes entitled to pension after 20 years, and ranks other than commissioned officers, they are entitled to pension in 15 years of service. Invalid pension, you said. Invalid pension is a very...
Before we move to the invalid question, I would just ask, because we always find that there's a family pension and there is a special family pension. And
yes, after invalid pension and disability pension, I'll come to family pension also, which has several subtypes. I'm just coming there. Yeah. I'll just reach there. Invalid pension is a very interesting concept. Invalid pension, and a very a concept which emanates from social responsibility of the government. In case of invalid pension, in case a person is discharged on medical grounds due to reasons which are not related with your service, whether it is civil side or the military side, which is not attributable to service, nor aggravated by service, and which has no connection with the with your service, government service, then a person is entitled to invalid pension. Now, for this, as per the interpretation of the government, 10 years of service was required. But various high courts said that no, invalid pension, once you're throwing out a person on medical grounds, then there is no question of any minimum service, because you are throwing him out. He does not, or he or she is not going out. And then later on, there was protection of Persons with Disabilities Act, which provided that a person cannot be discharged on medical grounds. But still, in certain uniformed services on the civil as well as the military side, that protection was not given. So the courts came to a conclusion that certain courts, they were conflicting judgments, that 10 years of service is not required. Now, this matter ultimately went to the Supreme Court, and it was referred to a 3-judge bench in P.A. Thomas's case. Now, the Supreme Court questioned the government that in case a person is not being granted the protection of service and you are throwing him out on medical grounds, him or her out on medical grounds, why will you hold back the pension, and why would invalid pension then require 10 years? So the government said that we'll clarify this matter. So the government took time, and very nicely under the supervision of the Department of Pensions and Pensioners Welfare, the government came out with a policy that yes, 10 years service is now not required for invalid pension, and any person who's discharged on medical grounds, even with 1 day of service, is entitled to invalid pension. Now, that letter is out and it has been granted. There are a few problems in that, again, a cutoff date, etc., which is not very evident on the civil side, but the matters have reached the honorable courts, and I'm sure the government will also clarify positively very soon. So that matter for pre-2019 retirees is pending, but I'm sure it will be suitably resolved by the government itself. So that's the concept of invalid pension. Now comes disability pension. In disability pension, since times immemorial, or especially since 1973, there is no minimum qualifying service required for disability pension. And on the civil side, it's called extraordinary pension. So disability pension under extraordinary pension rules also, there is no minimum qualifying service required from 2006 on the civil side. So disability pension is granted when the disability is treated as or declared as attributable to military service or government service or aggravated by government service. So and the rules are very liberal, and the courts have held that in case there's a disability which arises while a person is serving the government, and there is no note made that it was a disability which could have been which could have been incurred prior to joining service, then it is deemed as a disability which is related to service, and hence disability pension is admissible. This is the broad law. So disability pension is entitled to disabilities. It does not mean that, you know, a person says, for example, that a person has a heart attack due to excessive smoking, and a person says that please grant me disability pension, when the reason is recorded, or when it is recorded that, for example, a person just after 1 month of training, recruit training in a regimental center says that I've incurred a disability, although this disability was there with me during childhood also, but please grant me disability pension. So in such cases, these are a little controversial matters, but more or less, most of the disabilities, which are not related to a person's own substance abuse or alcohol abuse, etc., fall within the parameters of grant of disability pension as per, again, constitutional courts, as per law declared by the High Court, by the Supreme Court, the High Courts, and also followed by various tribunals. So that is, broadly speaking, the concept of disability pension. Then comes family pension that you were asking. Family pension, again, no family pension requires any minimum qualifying service, and even if a person dies, 1 day after joining service, his or her family remains entitled to family pension. Family pension, broadly speaking, are of 3 types. One is ordinary family pension, one is special family pension, one is liberalized family pension. This I'm talking of the military pensions. On the civil side also, broadly, they are the same, but they're called extraordinary family pension under category C, D, E, B, C, D, E. I mean, unlike special family pension and liberalized family pension, as we call on the military side. So both civil and military pensions are the same. The broad distinction is that ordinary family pension is granted at 30% of emoluments. It can also be 50% of emoluments for a few years. It's called enhanced family pension. 30% of emoluments. Special family pension, this ordinary family pension is granted when the death has no relation whatsoever, or it is not due to a disease, etc., and has no link whatsoever with your government service. Special family pension is when there is a link, or a remote link, or a causal link, or a casual link with your government service, and it is attributable to service or aggravated to service, or in a way can be related to service, or due to a medical condition which can in a way be related to have incurred in service. That special family pension is granted at 60% of emoluments. The third kind of pension is liberalized family pension. This is when the death is in an operational area and has some kind of a link with your deployment in an operational area. So, for example, a person is killed in action, or a person, let's say, suffers a heart attack at Siachen Glacier, or during any operational movement, there's a vehicular accident, or a person is patrolling and he falls down in a gorge or down in a valley. So such instances would give rise to liberalized family pension. Now, it is the same on the civil side for Central Armed Police Forces. The only difference is that rather than special family pension or liberalized family pension, it is called extraordinary pension, or family pension under extraordinary pension rules. Then there is war injury pension. Now, war injury pension is again similar to liberalized family pension in the sense that if a person dies, the family gets liberalized family pension. If a person suffers a disability in such operational areas, then he or she gets war injury pension. Then we have a concept called an old concept called reservist pension. So earlier we used to have people who used to serve in the reserves. They used to have some color service and some reserve service. Color service was your physical service when you're serving in uniform. Reserves was when you go home and you are free to follow whichever profession you want with skeletal training every year. after every few months, and you can be called out in case of an emergency. So you are free to follow any profession, but you can be called out. So that color and reserve service combined had to be 15 years to claim reservist pension. Now, again, in reservist pension, people who were voluntary retirees, who used to, after completing 15 color combined color and reserve service, 15 years, who used to seek voluntary retirement, they were denied by the government. But our High Court in Harjinder Singh versus Union of India held that no, once you complete your colored and reserve service of 15 years, it does not matter how your manner of exit from services, whether you're a premature retiree, whether you're a voluntary retiree, whether you're discharged by the government, does not matter. You're still entitled to reservist pension. Then a similar pension was special pension, and earlier known as mustering out pension. In such cases, if due to reduction in establishment, the government releases you from service after 10 years plus service, then you used to be then you're entitled to special pension. On the civil side also, it is the same, but in the civil side, it is not called special pension, because in the civil side already there's a universal rule without any ifs and buts that in 10 years of service, if you are discharged or if you reach the age of superannuation or retirement, you're entitled to pension under the CCS pension rules. So that sums up the basic kinds of pension. And if Mr. Chatra, do you have any?
Yeah, I will just check it out. Though I posted if anybody wants to ask.
But
personal questions we are not taking.
Yes, personal questions or questions related to personal litigation or your own personal case, we won't be able to answer here. It's not ethical. However, any broad question on pensionary policies or on any aspect related to law related to pension, please, most welcome to ask.
This is by Radhesham, though I'm slightly modifying it. It says how the anomaly in the ORP can be resolved, or whether there is any anomaly in the ORPs as on date.
Well, there were certain anomalies, and these were looked into by the one-man judicial committee. The one-man judicial committee, rendered its report many years back, and we are still waiting for the government to implement it. And once it is not yet public. So once it is made public and the government implements the recommendations, whichever recommendations are accepted, those anomalies are expected to be resolved. There is some litigation also going in the Supreme Court on OROP, but that's a sub judice matter. So basically speaking, OROP, yes, has certain anomalies which are being looked into by the government, as well as a few of them which are sub judice.
This is status of the case against freezing of the DR from the 18 months by the Government of India.
I'm not aware of any case that is pending. There was one in the Kerala High Court, but if you ask me personally, though it may not be desirable, but freezing of DA does not directly convey any illegality because it is freezing. However, reduction of any amount or retrospective reduction or decrease in your emoluments or in your pension, that is illegal. If that happens, it has never happened. It's a hypothetical thing, but that is illegal because that can only take place. Any reduction can only take place during a financial emergency proclaimed by the President of India, and it's a constitutional provision. The Constitution itself says that it can only happen if there's a proclamation of financial emergency.
I think you can look into the chat, because some of the suggestions only, like, what is your comment? Because personally, I feel commenting upon certain aspects will not be. But one question is disability pension taxable?
Currently, it is not, because there was a clarificatory letter issued by the CBDT, but that has been stayed by the Supreme Court. So currently, it is not. It is not taxable as of now, till the matter is being looked into by the Supreme Court. The status quo ordered by the Supreme Court. Do you want me to look into the chat roll once and answer?
Yeah, because I have seen, because a lot of questions are just like more like a general comment. What should be done?
Okay, I'll just have a look at the chat roll and try to answer. People can post a question on the chat roll, or will you unmute them if they want to ask a question?
Then they can post it on the chat that I want to be get unmuted, because there are a large number of participants. I will not come to know that who has raised the hand.
Okay, so any participant who may like to be unmuted for any particular question may just post on the chat roll and request to be unmuted to Mr. Chatrat.
Yeah, but again, the question will be in general, not for a personal.
Yes, please.
I suppose Major Satish wants to ask. Major Satish. And then Arun Khan Mishra. So you will have to unmute yourself, Major Satish.
Maybe now. Yeah. Navdeep, can you hear me?
Yes, sir, I can hear you, sir.
Right. Thank you very much for sparing some time like this. Now, can this, some sort of a letter is circulating by some middle rank officer of the DMA to proposing reduction of pensions. What's your view on that? For us, it seems absurd.
So this talk is not on that, but it's a very hypothetical thing. I don't think that can happen because pensions is not under the subject matter of, as per the rules of business, it does not fall under the DMA, and 99.99%. I'm not saying 100%, while it is 100%, no reduction in pensions will ever take place. The government is very sensitive to these things. It's not such a light thing. I mean, the government is absolutely sensitive about things, without whether it is government of party ABC or XYZ, any political party. I'm an apolitical person, so I'm saying so. It is a very sensitive issue. The government will not play around with pensions so lightly. It will not happen. So I would say that people should rest easy on that and not to worry. And even the military community is very sensitive about these things. It's just a voting sheet that has been floated at a very hypothetical proposal in that. I don't think it will come through, and people will understand, including the military hierarchy will understand.
The mere fact that they have made it public, I think, is stupidity itself.
So we can, I mean, this kind of conversation we can have in a drawing room, not in a public forum.
Fine. No, it's for everybody's consumption. It's not only for mine. Everybody's feeling very hurt and upset about it.
That's okay, sir. This talk is not about that, sir. This talk is on general. It's an educative talk on pensions. We can discuss that offline.
All right. Okay. I'll come back to you again.
Thank you.
Sorry for this conversation.
No problem, sir. Thank you. I'm just going through the chat roll also.
We are meanwhile unmuting Arun Mishra.
Right. Not Justice Arun Mishra.
No, Arun Khan Mishra.
I'm afraid. Because I just cited one of his judgments.
Hello, can you hear me, sir?
Yes, please.
Good afternoon to you, sir. I'm an SS officer released quite some time back in 1990.
Just a second. Mr. Chatrat, can you unmute? Can you mute Major Satish Khanna? I think Major Khanna's mic is still on. So that. Sorry, sir. We'll just.
This is not Justice Mishra. This is Captain A.K. Mishra, released officer.
I was just joking.
I too, sir. Thank you very much. There's a burning desire of all SS officers for pro rata pension from Army for the period we served there. We gave our 1+5 minimum and 1+14 maximum year of our youth to the Army without getting any pension from the Army. Point number 2, even in the civil setup, like I was serving in LIC of India, my services in the Army were not taken into account to give me full 33 years of service for full pension. Sir, 2 things: whether there is a justified demand of SS and ECO officers for pro rata pension for their number of years served in the Army. Secondly, why there is no automatic safety of our full pension in the civil setup, which is also a government setup like LIC banks, where we have served around 30 years. Although there is a rule 27 of pension rule LIC and pension rule banks, which clearly states that they can add to our qualifying year of service. Thank you very much, sir.
See, the answer to why is not for me to give. Why
it is a discussion, sir, and things are moving.
Yes, so why it is not there in the LIC, I cannot answer. But in case anybody is aggrieved by that or was aggrieved by that, it should have been challenged in case there was any illegality. Or in case, for example, the decision by the competent authority says that such service should be counted. But in the final regulation or in the final letter, there is no such clause provided. So it's challengeable. So without having a look at the regulations, I won't be able to comment on it. But of course, if somebody is aggrieved and somebody thinks that, there is some illegality and one rule supports counting of service and one rule does not, then it's a challengeable thing, and it should be taken to the concerned judicial fora, I would say.
Okay, sir. And secondly, my first question, pro rata pension for SSCOs.
Hello.
On the first question, I think already some matter is pending in the Delhi High Court, I hear, or somebody was planning to challenge it. I cannot comment on past retirees, but for future retirees, my future retirees or currently serving or future schemes to be introduced by the government, my opinion has been that the policies should not be exploitative, and some kind of a contributory pension scheme which does not even add to a burden of the government should be introduced. And the Coast Guard already has a similar scheme wherein they are under the NPS for their short service scheme. So I personally feel that it is desirable that policies should not be exploitative, and after either it should be just 5 years of service or after 10 years of service, there should be some financial backup. And fortunately, although the government has been alive to this, but still there is no final decision forthcoming for last so many years. And in a committee of experts of which I was a member, Mr. Parikar was very, very keen to have it implemented very soon, but it has not yet seen the light of the day. But I'm hopeful that with all of you requesting the competent authorities and also the Army, Navy, Air Force coming together and requesting and convincing the competent authorities, something should come out, and it must come out. We cannot have exploitative policies as far as our short service officers are concerned.
Good evening.
Thank you so much, sir. And can we talk to you sometime on one-to-one basis to clarify a few things?
You can send me an email, Mr. Chatra.
Good evening.
Okay, sir. Thank you, sir. Thank you very much.
Yeah,
good evening.
Wants to ask. Yeah.
Good evening, Major Navdeep.
Yes,
hello.
Sir.
You can post your question.
Yeah, this is regarding ordinary family pension, the distribution between the NOK, who's a spouse, and the parents of the deceased soldier. Is there a set percentage? How the parents can claim that? Do they have to take the litigation channel? Both ways,
Ordinary family pension cannot be divided. It is only special family pension and liberalized family pension that can be divided. And the situations and the circumstances in which SFP and LFP can be divided, those are mentioned clearly in Government of India letter dated 31st of January 2001, sir. But there is no division of ordinary family pension. There is division of special family pension and liberalized family pension in case there is destitution of the parents and after following a due procedure.
Thank you very much, Major Navdeep.
Thank you, sir.
This is the Arjun Bhatia. What is the current status of shelter appointment cases? And is there any appeal lying against that?
Somebody will have to elaborate that. Shelter appointment cases, appeal regarding which aspect of it? Okay.
Meanwhile, I will take one question because that would also come.
Whether the content
power lies.
Sorry?
Whether the content power lies before the AFT, or you have to go for the execution, or how to go about it?
See, you have to go for the execution. However, the Kerala High Court has held that not implementing the order of the Armed Forces Tribunal would amount to interference in the administration of justice, and hence the resort to contempt proceedings can be taken by the tribunal. The Punjab and Haryana High Court has also held that execution by exercising the powers of a civil court, that is attachment and by way of imprisonment, can be resorted to by the tribunal. So contrary to popular perception, the tribunal is not powerless. But of course, the members concerned have to be powerful and have to, take those strong actions whenever required. But it is not the power. It may be that the rules and the act directly do not, give direct powers to the tribunal. However, the high courts have held that they have full powers and they're not toothless at all. Mr. Chhatras, I can see many questions on the chat roll. I'll just answer them for 5 minutes. The ones which can be answered.
Because majority, some of these on the chat, I'm seeing that they are suggestions. What are your
No,
comments for us?
I'll just see which can be validly answered. So, for example, there's a question by P. Jadhav saying that on resignation cases, gratuity is not granted. No, gratuity, as per judicial dicta, gratuity is grantable on resignation cases also. And even, if a person resigns his or her commission, even pension is grantable. You can have a look at Colonel Bhargava's case, Union of India versus Colonel P. Bhargava by the Supreme Court. There is a question on someone who's low medical category and without disability pension from the Indian Navy. And so the answer to that is, please follow the system of representations and appeals to the system. If they are rejected, then you are free to follow the judicial process as deemed fit and as advised. Pension is reduced from qualifying service to 22 years. This question is privately by 0166E410. Well, that matter has already been resolved by the Armed Forces Tribunal.
Few questions have actually been repeated. Let's assume they were not unmuted. A lot of them have repeated it again.
So, some are repeated and some are
some are suggestions also. So I don't think,
yes,
I will just check it on the Facebook as to whether we have a question.
If a army officer serves for 15 years and gets released voluntarily, is he or she entitled to pension by Vivo 1718? No, as per the rules, he or she is not.
Manju Anand says, please explain the process to avail pension of the deceased by the LR.
Sorry?
Please explain the process to avail the pension of the deceased by the LR. It's not on the chat, it's on the Facebook.
Oh, it is. Yes. It's very simple. It's provided in the pension payment instructions. It's available on the website of the PCDAP. So there's a very simple procedure prescribed, but it will be better if you approach your pension dispersing agency. Even the banks are authorized to do this same, or the defense pension dispersing officer from wherever the deceased employee or the deceased pensioner was getting pension. It has really been simplified over the past few years. I'm just having a look at if an officer dies from, say, cancer, the officer is granted disability pension. Is the NOK also entitled to lump sum ex gratia payment? Again, it depends upon case to case. Normally, only for disease itself, you're not granted ex gratia compensation. But if there is a link, for example, if a person was suffering from cancer, he's driving somewhere or going to his office and he collapses, or he's on duty when he collapses, then that may give rise to the grant of ex gratia compensation.
It says, is there any pay protection regarding last round pay for PMR officers who join the government service after release?
It all depends upon the organization where you're joining. For example, in certain states, they give you the number of increments for the number of years you've served. In certain cases, on the re-employment basis, if you're there are complete re-employment central civil services re-employment rules 2010, and then now recently revised. So there's a complete system on how pay is to be protected. In banks, the system is different. So it all depends upon the organization which you're joining.
Yeah, because even otherwise, as law, we say that judgments are not statute. Rather,
Yes,
it is basically interpretation of the statute.
Yes. Then there's a question that AFT is deficient of judges. Why isn't government appointing? See, currently, the rules there were new rules made for various tribunals in India, and those rules were struck down by the Honorable Supreme Court. So the government then made new rules. Those are also challenged, and the judgment is reserved. So we don't see en masse appointments to any tribunal in India till the time the judgment is pronounced, and it still might take some time. However, recently about 8 members were appointed by the government. Those were pending selections. I mean, selections initiated earlier than striking down of the rules.
The last
this is an important question. How long is liberalized family pension given? it is given for the rest of your life. So it is at 100% of emoluments or 100% of notional emoluments and the rest of your life. And most family pensions are lifelong.
Yeah. Two last questions will be, some people are posting whether it is available on the YouTube. I'm just posting the channel, YouTube channel's name. Meanwhile, this is, sir, is it legal to introduce a policy to reduce pension due to financial burden?
No, not at all. Not at all. Not at all. Not at all. And does a case on invalidation on medical grounds with 10% disability for life hold grounds for disability pension? Well, if the disability is held to be attributable or aggravated by a court of law or by a tribunal, then in a case of invalidation, whether the disability is 1% or 49% does not matter. You're entitled to disability pension, and it is provided in the rules as well as Sukhwinder Singh's judgment of the Supreme Court. So for invalidation cases, even 1% disability counts for disability pension.
Yeah. Well, I've been told that one Captain Opal wants to ask a question. I will just check it out. Captain Opal. I'll see whether he has been logged in by Captain Opal's name only. This is, would it make legal sense and be worthwhile to get ECGH cover through either a stay on the MP6 denying online card application or binding them to perform a contract supposedly valid, enforceable and concluded by paying 1.2 lakhs in 2019, following which a temporary slip was issued?
Sir, this is a very fact-based query, and it has no link with pensions. It's ECHS is not a subject matter of this discussion, and every such query would be opinion-based, again on facts of each case.
Yeah, that's why we have said that they can share the mail with you. Now, the last question we will be taking: disability pension is a service element and disability element. Why is government not giving service element to premature retirees with less than 20 years of service in spite of many Supreme Court judgments?
See, that's the interpretation of the government, that as per them, the rules do not provide for service element with less than 20 years or less than 15 years in case of Jawans, saying that only invalidation cases with less than 15 or 20 years can be granted. But that interpretation has been set to naught by various judgments, and the judgments, starting from way back, Jai Singh's case by the Delhi High Court, then multiple decisions even by the tribunals upheld till the Supreme Court, and a latest judgment in the Navy by the Supreme Court that service element does not require any minimum length of service. And actually, as per law and as per rules, any person who's released in a low medical category at the time of low medical category, any person who's low medical category at the time of release as compared to which he was recruited in is to be treated as and deemed to be invalidated from service. That is what Rule 4 of Entitlement Rules says. And the same has also been upheld by the Supreme Court recently in a Navy case, ruling clearly that if you're in low medical category at the time of release, then irrespective of the manner of exit, you're treated as invalidated from service. So that is where the law stands. And people who have been people whose claims to service element have been rejected have approached the honorable courts and sought relief from there. So that's where the position is. Government is not giving, but they've been granted by the courts.
One is saying that Captain Opal has an important information, and
right.
He wants to unmute himself, but probably is not logged in by his name.
He can ask on the chat roll. He can give the information on the chat roll.
Yeah, that's what I'm saying. Once he posts the question on the chat, I can identify. Meanwhile, Kriti Sharma has asked your email.
I'll just type it out here.
And meanwhile, you can also share the link of the book which you have written, or the title.
Yes,
of
many queries on the book. Just a second. It's not going. The book is. It's okay. Sorry. It's. I'll just type the question. I'm unable to. Just a second. I'm just typing out my email. Yes,
Pradeep,
the book is available on, all discounted links, etc. are available on www.navdeep.info. All discounted links are available there. And in fact, I would like you to read the book, and it will answer many of your queries, and it will also give you all, latest judgments and the policy letters, and you might be able to help others.
A question, urgent question. Pradeep Juanda.
Yeah. Yeah, Mr. Pradeep.
Sir, I'm Colonel Pradeep Juanda, retired. I'm from 3 Punjab. During the last 2 years, we lost 6 Jawans, unfortunately, 3 in Siachen, and 3 during the recent fight with the China. So I'm following up the case from the unit behalf. I just want to ask that the government chief minister, which he has announced this thing, if not given, how to approach, which authority to approach so that the balance of money can be given, which he announced on TV and other platforms.
So when you're stuck with a wall in front of you and things are not moving ahead, the best way is this. First, represent, for example, if the chief minister has announced it of any particular state, represent to the chief minister's secretariat, send a representation, proper detailed representation addressed to the chief minister's office and also to the principal secretary of the chief minister with a copy to the Department of Defense Services welfare of the concerned state. That is one. Wait for 2 months. If nothing happens, initiate an RTI request and ask as to what action has been taken on your representation.
Right.
Under the RTI, please remember that you cannot seek opinions or what a personal opinion is, that why have you not taken action? That is not correct under the RTI. So you ask what action has been taken and what are the recorded reasons for not taking action till date, or where is the representation pending, or please ask them that please kindly inform the status of the
progress on the
grant, progress or the grant of such and such ex gratia compensation to such and such person.
And jobs, etc., which they announce for the
same way.
next of kin.
The same way. In case it does not happen, then take the legal route.
Right. That is the last resort.
Right. Yes, sir. Of
thank
course, please avoid litigation. Avoid
Yes,
doctors and lawyers.
I agree.
Avoid doctors and lawyers. Try to resolve your issues at your end.
I'm visiting the Zilla Sainik Board and other places.
Yes, sir.
Regularly.
Yes. Only if nothing works, then only litigation should be the last resort.
So the wife of one Shaheed has got a job. She has got Naib Tehsildar job from Amritsar. So we are thankful that way, and we'll progress further.
Yes, sir.
Thank you, sir.
Yeah.
Thank you, sir.
So Navdeep, we will be taking last question by Krishnamurthy.
Right. Mr. Chatrat, you can give them 5 minutes more in case because we don't get this opportunity again and again. You are also busy.
No, but this becomes another thing, just like serials, a sequel part 2. We can elaborate on a particular part on a disability pension, etc.
That's nice of Beyond Law CLC and you.
No, it's fine.
Okay, Major Navdeep, good evening. This is Group Captain Murthy.
Yes, sir.
My question is hopefully for a class of people. Post 2015 OROP, the PMRs have been placed outside the fold of any benefit of OROP.
Right.
That's what the point is. Is
Right.
there any possibility or is there any case for the set of OROP, premature retirees post 2015, to actually appeal against this? Is there any ground? Is there any even stand? Or not? That's all. Nothing more.
That would amount to rendering legal advice on a social fora. I don't think that's.
Then we'll write to you. I'll write to you. May I write to you?
Yes. But yes, sure. But I'm sure you are aware that even if you're not entitled to OROP, you are entitled to the notional fixation of pension under the new formula introduced by the government for all central government pensioners. That is also pretty a very progressive move. So the gap between OROP and current retirees or retirees based on that notional formula is not very high. I mean, some people were thinking that the gap is going to be very high. It's not very high. So you must examine all those three things: the normal pension, OROP pension, and the notional fixation formula pension. Whichever is the highest, you can opt for any of those. Only the OROP is not applicable to you. Other two formulae are applicable to you.
Okay, sir. Anyway, sir, understand. I mean, we'll contact you directly. I understand your reticence on the subject in this forum, and we accept that also. We'll approach you separately.
Contact any lawyer, so not just me. It's just
okay.
No, Aman has
any
posted
lawyer
your
in
email
your
ID.
jurisdiction.
I'm saying Aman has posted your email meanwhile.
Right.
And now, time and again, Mr. Mishra says that kindly unmute Mr. Uppal, but at least I have not been able to find him. Do you find him? Either he can raise the hand so that maybe he is logged in by a mobile number or some number else.
Doesn't matter. He can send an email, whatever is his query. We can't hold on to, to just locate the sign-in name.
The last question you can take, which is on the last chat, if you intend, then we wrap it for the day.
That's again a specific question on a sub judice matter and totally hypothetical. I don't think we can answer that. We cannot predict what's going to happen in a court of law.
So we can wrap it for the day, and then we will make it a specific issue webinar. So tomorrow's webinar would be on the Transgender Persons Protection of Rights Act 2019. It will be a short talk on that. So do stay connected with us. We have Adi Lakshmi from Madurai speaking on this said topic. And we have already posted on the chat box the YouTube's name, that is Beyond Law CLC, on what platform we have just connected today. And Mr. Navdeep, as usual, that since not only on the virtual platform, even otherwise we have been meeting you. So we know that your insights on the military law and all other service aspects is great. And it was quite heartening to know that people from Pan India and other people also did connect with us today for today's webinar. And meanwhile, someone has asked that where do we get the links for the webinars? I'm just posting in the chat.
Mr. Chatra, it's going to be available on YouTube as well as Facebook, I believe.
Facebook right now it's available. Anyone can go to the page itself, or they can also.
And you'll be posting it on YouTube, I think.
YouTube.
So people can just access
probably
it from
today
there.
or by tomorrow. It will be uploaded. Yeah. So thank you to all the participants who have been connected with us, and that too in and around the festival season as Diwali. Everyone stay safe, stay blessed. And I can only say this time have a more greener Diwali, and we believe that the corona goes and no longer the pandemic. And thank you, Mr. Major Navdeep, for the insights given by you. Namaskar.
Thank you, Mr. Chatra. Thank you, Mr. Chatra. Thank you, everyone.
Thank you.